rise. Court of Appeals Division 1 is now in session.
Thank you, folks. Have a seat. Give me just a moment. All right. Our microphone seems to have taken a bit of a turn, so I'll just keep adjusting it. All right. Good morning, folks, and we're here for oral argument in 1 CACV 25-0086, Lalliss versus National Liability. These proceedings are being video and audio recorded. They're being live streamed also via our court's YouTube website. We do ask for that reason that when you approach the podium, please state your name and who you represent, so everybody who is in the courtroom and also those who may be watching online know who's speaking. Each side has 20 minutes. Appellate counsel, you are responsible for keeping your own time. If you wish to reserve any for rebuttal, you're welcome to tell us, but we're not going to guard it for you. So let us know and make sure you watch your own time. You also should understand that we have read all the briefs. We have gone through the cases. We have conferenced the case, and so we are very well versed in what is going on in the case. For that reason, we do ask that you not repeat your brief, but also focus your argument on things that you think are critical that we understand that may not be fully expanded on the brief, or at least are critical for us. You do have the 20 minutes. Don't feel like you have to use all that time, but please use the time that you feel is necessary. With that, counsel, you may begin.
Good morning to the court. My name is Keith Lalliss. I represent my little brother in this matter. It is a case that is a surprise to me because we shouldn't have to be here. The trial court determined that there was an assignment of the workers' compensation award that was not legally done because of the fact that workers' compensation cases are personal injury cases, and they're not assignable before they're concluded. He also determined for some reason that despite the fact that nothing was ever done in this case by the insurance company, except for sending to me just before the young man that was injured was released from care, a check for something like $1,900. Because of the fact that that check was sent so late and was so short, I concluded that maybe I had a big problem with the insurance carrier and that they were going to take the position that we had an accord and satisfaction. So I just sent the check back. This young man that was injured was a tenant of my brother and had a wife, and they were living as most people do day to day from income that was coming in. There was nothing paid to him until the $1,900 check was sent months later. He couldn't pay his rent. He couldn't buy food. He couldn't run his car. He couldn't do anything because he had absolutely no money. It so happened that his wife was a granddaughter of his tenant, my brother, and he...
Well, counsel, why don't we focus not on the basis of why he assigned it, but the nature of the assignment? Because that's what we're here for. They're not saying, oh, he didn't owe your brother money.
Understood.
So why don't we focus on why we're here?
We're here because the insurance company didn't do what they logically could have done to keep us from being here. The assignment was done after I filed the matter in the Industrial Commission, and the Industrial Commission entered on an award. That award was based upon information that was submitted to the insurance company. The young man was earning about $2,500 a month. He's entitled to something like 2/3 of that under the workers' compensation statutes. They finally paid that $1,900 months later when the amount that was due was much greater than that. The reason why we're here is because after we got an award from the Industrial Commission, we got nothing from the insurance company except that $2,000 check.
Which he didn't assign to you, you returned it.
That's correct. It was sent back and it was never cashed. The reason why we're here is because of the fact that the trial court determined that assignment of the claim by the injured party to my brother was unenforceable because it was an assignment of a personal injury claim, which is prohibited. There are two cases that I've cited that...
Let's stay with the assignment. The statute says that it's not assignable. The claim is not assignable for workers' compensation benefits until a warrant issues. Does your brother, I guess, satisfy the warrant requirement?
You know, I checked on the case law, came up with, I think, about 600 cases having to do with warrant. Almost every one of them is a criminal case.
Of course, that's a very common understanding.
That's correct. But in this case, the assignment was made after a determination of liability and the amount.
But a warrant isn't a determination of liability and an amount. And a warrant isn't an award. Do you have any case law that says an award is the equivalent of a warrant?
The award is, in fact, statutorily an enforceable obligation.
So are you saying you could take the award and walk over to the treasurer and say, hey, you have to pay me based on this award?
Yes, that should have been done.
What is a warrant in this case? As you pointed out, warrant in criminal cases is different, but what is a warrant here?
A warrant is, in fact, a determination or a settlement. Settlement is a separate issue, but I'll discuss that in a moment. The warrant was accomplished by the fact that the Industrial Commission, which has statutory authority to do so, determined the claim itself and established a means for calculating the amount.
So cases an Arizona statute, including Title 23, references warrant in other places. And in those contexts, it is, for example, in 23353C, that the employer has to pay wages or compensation due to the employee in lawful money of the United States by negotiable check, draft, money order, or warrant. So those are the kinds of things that are a warrant. There's something that you can take, like a check, a negotiable instrument of some sort, and issue it. Other cases in Arizona, going back to before statehood, have talked about warrants in this fashion. I understand the parties didn't seem to come across them, either side. But how is an award a warrant when it's got to be something like a negotiable check, draft, or money order?
How would I get something like that? I spent a lot of time trying to determine what you're asking. And
well, I'm
there's
dealing with statutory interpretation. So 23353C says that. And it was pretty simple. It just put the word warrant in and search Title 23. So I found it pretty easily. I understand you didn't, but now you do have to answer the question, because that is what we have to answer. How is an award like a negotiable check, draft, money order, or warrant, a negotiable document of that sort?
I don't know that what we're talking about really is necessary, Your Honor, because of the fact that you can assign a personal injury claim.
Not a workers' compensation. Let's focus on workers' compensation. You cannot assign a workers' compensation claim until a warrant is issued. That's what the statute
unless it's
says.
settled. Botma says, such an assignment, if made or contracted for prior to settlement or judgment, is the legal equivalent of an assignment and therefore unenforceable.
You're dealing with a personal injury assignment. Is that what you're talking about?
Yes.
Workers' compensation needs a warrant. Did you have one?
We had a settlement. They have never contested anything. They've just never paid. They have agreed all along that the young man's claim was valid. They've agreed all along, and they even tried to pay a part of it with that $1,900 check. But they have never contested anything. And the award is, in fact, a judicial determination by state law.
But the statute doesn't say a judicial determination, does it? Just to answer that question, it does not say a judicial determination.
It says it in a roundabout way. And
It says a warrant, not a judicial determination.
How would I go about getting a warrant? I got an award from the Industrial Commission, which has exclusive authority to do so. What kind of an action would I take to get a warrant?
Or any kind of negotiable instrument. Why don't we move on to your claim with regard to bad faith? What evidence did you produce, in particular, of the damages, the bad faith damages, that Mr. Kosar suffered?
I'm sorry, I didn't get the last part of that.
To bring a claim for bad faith and to survive summary judgment, you have to establish or introduce some sort of evidence that the carrier worker had the relationship. There was no reasonable basis for denying benefits in the policy. The carrier's knowledge, but then you also have to prove the fourth element, which is traditional tort damages proximately caused by the denial of workers' compensation benefits rather than the damages resulting from the workplace injury. damages from pain, humiliation, and inconvenience, and pecuniary losses. What did you come up with? What did you come forward with for him?
I introduced in the motion for summary judgment everything that was necessary. I do not understand why the trial court did what it did. There's no question but what they never paid, except for that attempt to send me a $2,000 check. They never paid the claim. They didn't pay it on time. The Zillage case gives you all the instructions from the Supreme Court as to...
But, Mr. Lalliss, I think the question he's asking you is what evidence of damages did you present to the trial court that would allow you to go forward, that would preclude the entry of summary judgment against your client? What evidence of damages did you present?
For Mr. Kosar.
Everything that they were supposed to do under the statute, under the Zillage case, was never done. They never did anything that they were supposed to do.
Okay, and let's say that we agree with you that you've established those elements of bad faith. The case law still establishes that you must have, that must result in some damages. You can't just have bad faith in a vacuum that doesn't harm anyone. It must end up causing damage, in this case to Mr. Kosar. Did you have any evidence, or did you present any evidence to the court in your response to the motion for summary judgment of those damages?
Yes, he was never paid.
Anything other than that?
Well, that's enough. The main obligation that the statute puts upon an insurance company that's selling those policies is what the Zillage case requires, that they quickly and honestly and completely do what the statutes require them to do. They didn't do anything.
As I read your complaint, you are requesting two forms of damages. You were requesting the unpaid sums that you believe that Mr. Kosar was entitled to, and you're requesting punitive damages. Those were the two elements of damages that you requested in your complaint. Am I correct about that?
You're correct.
Okay. So I guess my question is, beyond the unpaid sums, were there other damages? Did you disclose or did you present the court with any evidence of other damages that Mr. Kosar suffered based on the lack of timely payment? Or was it just the amount of the payment?
Well, the very fact that the reason for the statutes under Title 33 is to make sure that if a person gets injured on a job, that they have a way to buy the things that they need to live on. The payment is a little bit less than what the salary might be, but he was earning $2,500 a month that suddenly was gone.
And did you present, for instance, an affidavit from Mr. Kosar establishing for the court how that damaged him, the lack of timely payment?
I don't think that's necessary, Your Honor. I think that just simply failure to follow the requirements of the statutes becomes bad faith.
But damages. My review shows that you said that he was entitled to bad faith damages as a matter of law in responding to summary judgment. And then in reference to Zillage, the only other time that you used it was at trial, the jury awarded $1 million in damages. From my review of your summary judgment, that's the extent of your damage discussion. How does that show the damages that we would be required to conclude were alleged and that there were material issues of fact about those? From those two statements, owed it as a matter of law or liable as a matter of law, and some other jury in some other case gave $1 million in damages.
The only thing that would be necessary, and I've only got 3 minutes left on the count here, the only thing that would be necessary to show is that they didn't pay it on time, and they left that young man in a situation to where he had absolutely no way of paying for any of his bills.
And I know you're saying that, but I have no evidence of it in the record. I understand you're saying it, but I don't have it from Mr. Kosar, do I?
Well, I'm not sure I follow exactly what you're contending.
Okay.
But as far as I'm concerned, the assignment of the bad faith claim is not prohibited. That assignment was a part of the assignment that was made, and that's legal.
And I don't think anyone's disputing that you could take an assignment of the, well, we may not need to reach it. I understand it actually is disputed, but we're focused really on the evidence portion.
The assignment of the personal injury claim,
It can't be a personal injury claim. It's a workers' compensation claim that was
there's no
assigned.
difference in law.
One requires a warrant.
Why is it that of all
I
the
wish I
claims-
could answer that question, but I wasn't around in 1930 when they wrote this statute.
Neither was I. The warrant, as far as I'm concerned, was satisfied by the award from the Industrial Commission.
Thank you. Did you want to reserve the rest?
Yes, I've got 1 minute left.
Yep.
Thank you.
Counsel?
Good morning, Your Honors. John Whitwer for the Appellee National Liability and Fire Insurance Company. With me also is my associate, Sid Lewin. I wanted to address some of the discussion that you all had with opposing counsel. And I wanted to correct some what I believe are misstatements. First of all, nothing was done in this case except sending the check for $1,900 is what the appellant is contending. That is not correct. The carrier handled this case reasonably. It accepted the claim. It investigated. It attempted to issue payment. And
Has it attempted to issue payment for the amount of the award? And I don't know if that's in the record one way or the other.
it is not. That's one thing I was about to get to also. In the amount of, this is one of the things, there's many things that were said here this morning by opposing counsel that are not in the record. $2,500 a month average monthly wage, not in the record. The Industrial Commission did not make that finding, and the fact that Mr. Kosar allegedly was living day to day, that he couldn't pay rent, that he couldn't buy food, that he couldn't take care of his car, that he had no money, none of that is in the record. The amount, not only is the amount of the average monthly wage of $2,500 not in the record, I don't know if that's correct or not. The Industrial Commission would have needed to figure that out and then issue some certain type of award, which could then be reduced to a warrant.
Which is the point with the award. You couldn't walk into anybody and say, this award is worth $2,500, give me $2,500. Because the amount wasn't even there, so it's nothing close to a negotiable check or a money order or what is commonly referred to as a warrant, which is what governments issue all the time for payment of their funds.
Absolutely correct. Couldn't said it better myself. That's the heart of the case right there.
Mr. Whitwer, was the $1,900 check a warrant or an equivalent of a warrant?
I think if you deliver, I would go to the Vukovic case to answer that question, Your Honor. And in the Vukovic case, there's a couple of comments that the court made. Vukovic versus Osick, Supreme Court of Arizona in 1937, and the court said, clearly the purpose, they quote the statute, quote, compensation, whether determined or not, shall not prior to the delivery of a warrant, therefore be assignable, close quote. And then the court explains, quote, clearly the purpose here was to render it impossible for the injured employee or his dependents to assign his compensation before it was paid to him or them, close quote. So Judge Beck, I think the answer to your question, based on this guidance right here, would be if you have the money and you get the money, that might be another case where you would then assign that money. That's how I
So
read
the check
that.
would have been, and had he retained the check, that might have constituted it, but they returned it, so they no longer had a warrant at that point.
Truthfully, I think my understanding of a warrant is less than Your Honor's, because I don't quite understand why they didn't have a definition, or I was unable to find an actual definition of a warrant.
There isn't one.
And so I think that we would be at least a few steps closer to having a warrant if he had the money in hand, and then he tried to assign that. That would be a different case. And then...
My understanding, and this isn't in the record, but just to holistically understand, is that when folks handle workers' compensation claims as attorneys, the payment then from the carrier goes to the lawyer, who then divides it up, because at that point the lawyer can exercise a lien, but it's not until the lawyer gets the payment. Is that accurate?
I do believe that there are cases where that happens. In this case...
Right, I'm talking generally speaking, when a lawyer represents a workers' compensation claimant, they do get paid, and they get paid out of the workers' compensation benefits.
Correct.
But it's done after the fact. It's the payment goes to the lawyer, who then divvies it up and says, I take my piece, here's your piece, and they're responsible then at that point to get the money to the claimant.
I do believe that's correct, that's the way it works, and sometimes even...
And that conforms to the statute, because at that point the lawyer has the equivalent of a warrant and the money's there.
I could see that, Your Honor, yes. I think, just for the record, in this case, the check was, and this is in the record, the $1,900 attempted payment was made payable to Mr. Kosar directly, because he was not represented at that time.
And he could assign it.
And he could have assigned it. I think he could have. Yeah. Now he couldn't have assigned a bad faith claim. That's a separate thing. You can.
Let's leave that aside for
Okay.
the moment.
I don't think the court needs to reach that question. The other.
What was the name of the Vukovic case, or the citation to it again?
Oh, yes, sorry. Vukovic versus Ossick, OSSIC, 50 Arizona 194, Supreme Court, 1937.
Thank you.
Also from that case, while I have it in my hand, last page of that case, this is interesting. Quote, this is true because compensation may not be taken in payment of debts of any character, close quote. It's exactly what they're trying to do here. They're trying to take compensation in payment of a debt. That debt is not in the record, but that's the argument.
And it's the history, at least it's hinted at in some cases. I'm not going to say that I'm going to find this, or the court would conclude it, but that the concern about the unscrupulous person who will take an assignment of a worker's compensation benefits for $10, and then suddenly the person has only $10, but the other person gets all the benefits. That's what the concern is, correct?
Correct. And that's an excellent public policy reason why this shouldn't be allowed, is because the public policy of workers' compensation is to get these injured workers taken care of. And that's in the Constitution and in the statutes and in the case law. And we want to give them the medical care that they need, and we want to give them some income replacement, and in some cases death benefits. And so there's all kinds of workers' compensation awards. They come in all shapes and sizes, and to say that a workers' compensation award is equivalent to a warrant or even a judgment is not accurate. So not only was that argument, by the way, waived, because it was not raised below, that a warrant is equivalent to a judgment, but it's inaccurate as well. There was no determination, just to be clear, the Industrial Commission made no determination of amount certain. The other statement I wanted to address was that, quote, we had a settlement, close quote, is what opposing counsel said. There has been no settlement here. There have been attempts to pay the money that were not met with cooperation and were rejected, but there has not been a settlement. And so if the suggestion is that there was, by the carrier's attempt to make a payment, that somehow constituted a warrant because there was that was supposedly an acknowledgement of an amount certain that was due, no, that is not a warrant. That payment was returned. It was not accepted. The other, the reference to the Botma case. Counsel referenced the Botma case. Botma supports our position. That's you can't assign a legal malpractice claim. That I don't know how that supports their position. Judge Gass.
Let's switch gears to the bad faith claim. And the court said in its ruling, the Superior Court, that plaintiff failed to provide the court with even a scintilla of admissible evidence supporting his bad faith claim. Once defendant challenged the merits of plaintiff's claims, defendant was required to present admissible evidence. He failed to do so. And when questioned about the lack of evidence at oral argument, plaintiff's counsel told the court that defendant admitted his allegations, which isn't accurate. As the court said, that statement is not supported by the record. What evidence, and let's just go through the damages element, but then we can talk about the others, because there are 4 aspects to the bad faith claim. So starting with damages.
That's exactly where I was going, yes.
Okay, go for it.
Yes, I agree with your point there that to focus on the damages, there was no evidence presented it is on damages. It is an essential element of the bad faith claim. You can't just skip over it. You can't presume damages. It's not like defamation per se. You have to show actual damages, and they have to be separate from non-payment of workers' comp. And the Industrial Commission...
What about punitive damages?
Punitive damages was not even raised in the summary judgment briefing by the appellant.
It's in the complaint, isn't it?
It is in the complaint. There's absolutely no evidence of that clear and convincing evidence. Evil hand guided by an evil mind is, of course, the standard for punitive damages. And in this case, at best, there is what the Neal case and
okay, but you're arguing entitlement to punitive damages. I'm saying he pled punitive damages. Typically, when you're doing a disclosure, you're not going to disclose a specific amount of punitive damages. That's something for the jury to decide. It's like general damages for pain and suffering, that type of thing. You're not going to give a number.
Correct.
So why is what your opponent put in his complaint not adequate to get past summary judgment on punitive damages?
Because there's no evidence. There was literally
evidence of what?
There was no evidence. There was no evidence of evil hand guided by an evil mind. So there was no egregious misconduct here. No misconduct at all. They didn't do anything wrong. The undisputed evidence, at best, shows inadvertence, which is definitely not
Can
enough.
he get punitive damages in a vacuum? In other words, doesn't he have to have the underlying bad faith claim?
That's an excellent point, Your Honor. You must establish a bad faith claim in order to get punitive damages. And
you can even establish a bad faith claim but still not establish punitive damages. In fact, you can lose that claim on summary judgment because of the higher standard of clear and convincing evidence.
Correct. We try to move for that all the time in the alternative. So absolutely.
So if we find his bad faith claim doesn't survive, what do we do with punitive damages at that point? Do they just go away?
It would be reversible error to say anything else than the punitive damage claim fails as well. That's clearly the law of this state, as you just pointed out. So,
So what the case specifically says, and I'm just going to read it verbatim, and this is from, I'll tell you, from Merkins, which said, traditional tort damages, approximately caused by the denial of workers' compensation benefits, rather than the damages resulting from the workplace injury, specifically the damages for pain, humiliation, and inconvenience, and pecuniary losses. So, what evidence did he have of that?
nothing. Zero. There was the lawyer argument today that you heard that he was destitute and that he wasn't able to get food as a result of this. There was no evidence actually of that. That was not introduced. And so that's just lawyer argument, and that doesn't count. The failure to pay the claim, if you don't like the way a carrier has, you disagree with the amount that they've paid, you don't think that they have complied with the ICA Industrial Commission's award, the Industrial Commission has exclusive jurisdiction to establish the amount of workers' comp benefits. And so that's the proper tribunal for that kind of dispute. And so if there's anything here, there was maybe a disagreement about the amount of workers' compensation benefits, which you can't go to Superior Court and argue that you should have gotten more workers' compensation benefits or that it was incorrectly calculated. And there was nothing that, other than that argument, as you heard from counsel today, that's their argument, that they didn't pay the claim.
So we've got the carrier and the injured worker. Mr. Kosar had a relationship. That's because insured-insurer relationship.
Correct.
First element. Then the second element is the absence of a reasonable basis for denying the benefits of the policy. So is there any evidence of the reason at all that the carrier at this point apparently hasn't paid? At least there's no evidence that the carrier has in fact paid. The check's been negotiated, Mr. Kosar got the money.
So the evidence specifically on that is in the statement of facts that the carrier presented. They put in a copy of that check to Mr. Kosar, and so that's one pretty significant piece of evidence, in my opinion, going directly to your question about what's the evidence that they tried to handle this claim correctly. And of course, that it's undisputed that check was not negotiated; it was returned. Apparently because of this accord and satisfaction.
Was that check intended to be payment in full for Mr. Kosar's claim?
I do not know, Your Honor. I don't want to talk out of line. I believe it was at the time. I believe that they thought that they had completely and properly handled the claim, and that was the payment that was owed.
Was it sent with a release document?
No. I don't think that it's customary, not to my knowledge. I don't think that would be, in my just enough to be dangerous experience with workers' compensation, customary to put a release in, because workers' compensation awards can be reopened under specific statutory
But here you have the
circumstances.
temporary, it's a temporary total, it's an award for a specific time period, like 4 months, right?
Correct.
Temporary total disability, temporary. So you'd think that if the carrier wanted to take care of that there would have been, hey, this is the payment, $1,900, this covers this amount. If you have additional injuries, that won't be covered, but there's nothing in the record like that.
There would have been a notice of claim status. I don't have that off the top of my head. It's in one of my fat books over there. But I expect there would have been a notice of claim status that they likely put in the summary judgment statement of facts. That would be customary. When you give the money, you give the notice of claim status, giving that kind of explanation that Your Honor just said.
Right.
Not a release.
Right. Just saying this is for payment of what's happened so far in the case. Yeah, because workers' comp cases, until there's what's the technical wording, until it's a closed case, until the worker it's determined that there is no further injury claim, and I can't remember the legal terminology off the top of my head, but until that event happens, there's still going to be claims along the way, potentially.
Correct. I mean, you can have a situation where a worker is paid temporary disability, and then that's not the end of their benefits. They may be entitled to some supportive care later. They may reach maximum medical improvement.
If according to the documents that I've gone through, if the record at 28 showed that your client actually issued a notice of claim closing his temporary disability claim and telling him to protest within 90 days if he wanted to, would that be consistent with your understanding of what they would have issued with that check or at the same time as that check?
I believe there was a closure and a 90-day deadline, something along those lines. Yes, Your Honor, is my understanding of what happened. And then, of course, the point of temporary total disability, temporary disability benefits is to get the money in the worker's hand right then when they're temporarily disabled and they need that money right then and there, not 2 years later.
Is there evidence in the record that the 1938 was not sufficient to cover his claim?
No evidence. No evidence.
So there's the check from the record. All we can say is the check was issued and that was what your client calculated, but there's nothing to prove that it was insufficient.
No evidence contemporaneous with the issuance. So in other words, there was, of course, later, 2 years later,
Right.
A 1061J hearing, and then they said that he gets more. Now, but there was no evidence that the $1,900 payment at the time was deficient. I see I'm out of time, Your Honors.
You are.
Thank you.
Thank you.
I have never seen, in all the years that I've been practicing law, anything that to me would seem to be as simple as this case. Is there bad faith involved? Absolutely. They never paid anything. They attempted to pay the $1,900, but at that time, they had the ability to calculate what the Industrial Commission determined they owed. It was somewhere around $5,000, not $2,000, but it was for months that the young man was out of work. And the $1,900 was a joke, really. But what you're facing here is simple. Number one, everything that could have been done was determined before the assignment was made, years after this event occurred.
Excuse me.
The assignment was made legally because of the fact that the Button case and several others, including Allstate versus Druk at 118 Arizona 301. In that case, it says, whatever the form, whatever the label, whatever the theory, the result is the same. The policies create an interest in any recovery against the third party for bodily injury. Such an arrangement, if made or contracted for prior to settlement or judgment. Now,
And counsel, I'm going to let you end with that quote because you are at your time.
Okay.
Thank you.
thank you.
All right, thank you, folks. We appreciate the briefing and the oral argument here today. We will take the matter under advisement, and we will issue our ruling in due course. In the meantime, we're going to stand at recess while the clerk set up for the next hearing.